It's my great privilege to open this ceremony today. So I'd like to start by acknowledging that we meet on the traditional lands of the Ngunnawal people and to pay my respects to the elders past and present and to any Indigenous people in the audience. So the purpose of today's oration is about reflection. So I think we're both reflecting on the past, but also reflecting on what we as individuals and also as an institution and as a profession are going to get out of the coming year. I think it's fair to say that it's been quite an unsettling time in the Canberra region, both towards the end of the last year and at the commencement of this year. But I think there's a lot to be optimistic about. So on that basis, we're really honoured to have Michael Kirby deliver the inaugural Canberra Law Commencement oration. It's an event that brings together the profession, student staff and the wider public. This particular event kicks off an annual series of lectures by distinguished practitioners and academics on emerging matters such as the law of robotics, genomic privacy, timeless issues such as the boundaries of personhood, and importantly, questions about justice. Michael has made an exemplary contribution to justice throughout his writing, his activity in leading Australian courts, notably the High Court, and indefatigable involvement in a range of United Nations bodies. We've been fortunate to hear him speak of dealing with the Vatican and with systemic human rights abuses in North Korea. A reminder for law students in today's audience that rule by law is not the same as rule of law. Michael's achievements as a jurist speak for themselves, and I hope that he will touch on particular aspects in answering questions from the student panel today. In introducing him, I want, however, to highlight an aspect of his achievement that is salient for law students, novice legal practitioners and academics. It is something that we all should emulate. Michael is distinguished by both his generosity and his effectiveness in engaging with students, the media and community. That's a manifestation of his commitment to justice and his recognition that law is a matter of people and not of textbooks or of return on investment. It involves leadership, energy and creativity. It needs to be communicated to the people who are affected by law, you and I. And that's the commitment of all the staff of the Canberra Law School and a set of values that we challenge our students and graduates to embrace. So please join me in welcoming Michael Kirby.
The University of Canberra on the occasion of this inaugural commencement address. Commencement addresses are very common in the United States of America, where often they double up as graduation addresses. But unfortunately, we're not going to give out degrees today to the beginning students. They've got to go through the hard yards of their studies before they come to that glorious moment. But this commencement address is something new and it's innovative and it's new, as far as I am aware, in Australia. And I'm pretty aware of what's going on in the many law schools of our country. I also want to acknowledge the Indigenous people, those of this part of our continental land, and also the Indigenous people right across our huge country, remembering the many wrongs that have been done to them, which it is the responsibility of new generations, and in particular new generations of lawyers, to correct. And I hope that some of the reflections today may be a contribution to that purpose. I've been coming to the University of Canberra virtually every year in recent years, and talking about my activities, mostly in the field of international human rights. I'm not going to talk specifically about that subject today, but it may be that during the Q&A, which will follow these remarks, there will be an opportunity to talk about what has happened to North Korea, what has happened to the interventions with the Roman Catholic Church, about which I talked on a previous occasion, concerning LGBT people and their rights, and all the other myriad of issues in our world that challenge human rights and equality for all people. I'm especially glad to see here my old friend, Professor Kim Rubenstein, who is returning to Canberra in order to take up her position as deputy head of the centre here. I pay respects to Professor Wendy Lacey, who is another old friend of mine who contributed to my Festschrift after I left the High Court back in 2009, and to all members of the faculty who are here present. It's a great thing to be once again at the University of Canberra. I like the University of Canberra because first of its beautiful campus, which fortunately was spared some of the worst of the ravages that have beset Canberra in recent weeks by reason of the bushfires and the smoke and then the hailstones. It was a set of pestilences that were sent upon us, and not for any sins on our part, but we should think about those who have suffered in the recent bushfires and now the floods, and draw our inferences about the importance of policy that must be developed by our government representing all of us in order to react to the basic source of the radical changes in our weather patterns and do something about it. And praying is a good thing, and I pray quite regularly myself. My partner doesn't pray because he thinks it's a lot of hocus pocus, but those of us who are religious, or even little religious, will say our prayers, but saying prayers alone is not enough, and you sometimes have to help the Almighty to deal with the basic problems, including the basic problem of humanity concerning nuclear weapons and their control, and the basic problem of humanity concerning climate change. The University of Canberra is well known in Australia for its accessibility to its students. Many of you here would not know it, but there are law schools in our country where the academics are locked away and you have to have a pass and a swipe card and other means in order to even get to talk to them. This always shocks me because in my time as a law student, you simply knocked on the door of the professor gently, so it wasn't rude, and then you would go into their presence. And this is a feature of the University of Canberra. I don't agree with academics being out of immediate contact with those who are their charges and who are in their responsibility. But also, the University of Canberra is very diverse in its ethnic composition and in the background of the students. I don't think it is true of the University of Canberra Law School, as it certainly is of many of the other law schools, that the majority of the law students had a private school education. Now, all of my school education was in public schools, but the fact of the matter is that when I was a Justice of the High Court of Australia, for most of that time I was the only justice whose education had been in private schools, although 67% of Australians are educated in public schools. and I welcome those students who are present from a private school background. Teachers are teachers and they love their students and help them and work for them. But I especially want to welcome the fellow students from public schools. Hand up those who are here who went to Australian public schools. That's terrific. Thank you. I also know that the University of Canberra has a very good record in placement of its students after they finish their years at the university and in getting them jobs in the legal profession. One of the challenges that is facing law now is finding enough professional positions for those who are coming out of the increasing number of law schools. When I was a student at the University of Sydney, there was only one law school in the state of New South Wales. That was the University of Sydney, and only one in every other state of the Commonwealth, and there was one in the Australian National University, but that was it. And now I've lost count of how many there are. Recently there were 40, but perhaps as I've been sleeping, there has been another one established and there's 41. But it's a lot more law schools, and that means a lot more law students, and therefore placement is extremely important. And I'm pleased to say that the University of Canberra does better than many in that regard. Now, I said that today I would like to talk about legal history. I'm very interested in history. I put it down to my father. My father was very interested in history. Though he didn't have a university degree, he was a great reader. He read to his children. And all parents should read to their children, because the capacity to tell a story and the capacity to listen to and appreciate the stories of this world, and if you're a lawyer, the way the law is a set of stories of crises, of injustices, of individual wrongs and wrongdoings. All of this requires storytelling, and my father was a great storyteller. Many students, when I go to the 40 law schools, tell me that they like my reasons in the High Court, called judgments. And I say to them, why do you like my judgments? And they say, because we can understand them. I think the reason that judgments become liked is when they can be understood and are easy to read. They needn't be difficult to read. If they're difficult to read, it often means that the writer has not thought through all of the issues that need to be explained. There's another reason, and that is that for some purpose, I think it's my father's skill in telling children the stories he wanted to impart. I believe I write in the way we speak. English is a language of two contents. It is the basic Germanic language of the Saxons that we speak in the kitchen, but on top of that has been grafted the Latin-based French language that William the Conqueror brought over to England in 1066. And therefore, for every concept in English, we have two words: last, will, and testament. Will is the German word, will. Testament, testament, is the French word. And we therefore always have two words. That's why our literature, our poetry, is so strong, because we always have two words, and therefore we have an abundance of language to express ideas. But in the law, most judges write in the French of the scribes that came over with William the Conqueror. I always wrote in the language of the kitchen because that's easier to understand. I invite the students and even the scholars who are here today to take a look at the reasons in the High Court of Australia and other leading courts and see if they can detect this phenomenon, which I declare is a reason for clear writing, full stops, short sentences, and the language of the Saxons. That's the way to make writing clear. And the subject that I want to speak about can be spoken of clearly because it's a subject where the law and law teaching has changed in my time as a practitioner and as a judge. When I was at the Sydney Law School, along with all the other law schools in Australia, legal history was a compulsory subject. In fact, there were 16 compulsory subjects. There were a few optionals, like industrial law, but there weren't many optionals. Fundamentally, the course was a course of compulsories, and everybody had to do them. Later came the priestly 11, which reduced the compulsories to 11. And many important subjects dropped out of the compulsories and more people started to do optional courses on Chinese commercial law and South American attitudes to criminal intent and other subjects of highly specific character, but that was not the way it was in my day. Everybody had to do the 16 subjects, and one of them was definitely legal history. In every law school, everybody had to study legal history. And some of the ancient scholars who are here with the faculty today may remember those times, but it is not the fact today. I delivered a lecture on the decline in the teaching of legal history, and for that purpose, I did what many lawyers never do. I actually sought out the empirical data, and I secured an investigation by the head of the Law Dean's Committee to find out what law schools taught legal history. There was only one law school in Australia when I did my research which had a compulsory subject in legal history, and this was Notre Dame Law School over in Fremantle in Western Australia. There were a small number, I think 6, that occasionally had optional courses in legal history. One of those was the Australian National University, but most law schools didn't have any course in legal history. The number of law schools that didn't have courses in legal history, of the 40, was about 31. And therefore, that raised the question, what are the students missing out on? Does it matter? Should we be concerned? And what should we do about it? And this is what I want to talk about today. I do so because the law is basically a story of the fight between form and substance, and between liberty and the struggle for liberty, justice and equality. And therefore, having a course in legal history can help law students to see the law of the present in the context of the history that led to the law being as it is explained that it is. And this is why I think teaching of legal history is an important course, even if it should not be restored as a compulsory subject. It should definitely be much more available and much more taught. And academics who have skills in teaching legal history should present their wares and be available for appointment, because I hope that there will be a rise in the teaching of legal history. One of the reasons, I believe, for the decline in the teaching of legal history had itself to do with a historical movement and development. This was the reduction in the role of judge-made law. When I was at law school, most of the law in Australia, most of the private law, was common law. And in the course of learning a subject like contracts or torts or subjects of commercial law, you would be taken through the history of the way judges had approached problems and used earlier judgments in order to reach the principles that applied in their particular case. With the development of parliamentary law, that is statutes and law made under statutes, the number of principles of law that were expressed by the judges in the language of judgments fell, and the number of principles of law and binding law that were expressed in statements made by Parliament in statutes rose. And that process has continued since my days at law school in the 1950s, right up to the present time, and is in fact continuing to increase. Along with that development came the end of the links, the formal links between the Australian legal system and the courts and judges of England. When I was at law school, it was extremely important for us to study not only the decisions of the High Court of Australia and the highest court in our state, but also to study closely the decisions of the higher courts in the United Kingdom, including when those courts were part of the Australian legal hierarchy. In my time as a practicing lawyer, for most of that time, the highest court of Australia was the Judicial Committee of the Privy Council. That was the ultimate court of the Australian legal system in all cases except a small number of constitutional cases that were reserved to the High Court. One by one, steps were taken in the federal parliament to reduce the number of appeals that went to the Privy Council. The first was an act of parliament to reduce cases going to the Privy Council that involved the interpretation of federal legislation, and then cases that involved the exercise of federal jurisdiction, and then cases that involved appeals from federal courts, and then ultimately appeals from state courts. As it happens, I was presiding in the Court of Appeal of New South Wales in 1988 in the last case that went from the Commonwealth of Australia to the Privy Council. That was a decision on the law of equity, and the decision of the Court of Appeal was appealed to the Privy Council. I'm glad to say we were upheld and not reversed in the last decision of the Privy Council in an Australian case, which would have been most shameful if we'd been overruled in that case, but we weren't. A ceremony was held farewelling the Australian lawyers, but until that time, a very important part of the preparation of many of the top lawyers was to get a brief in the Privy Council, to go over there. And because the Privy Council was the last appeal court in the Australian hierarchy, the lawyers would look very closely and be enjoined in their law courses, study the decisions of the English courts, because it's very likely that those decisions will influence the judges in the Privy Council, who are all senior English, almost all senior English judges, and who would give effect to what was the ruling orthodoxy in the United Kingdom. And so this was the world in which I studied and practiced law. And when I was a young person, I subscribed to the Commonwealth Law Reports and the Australian Law Journal with its Law Journal reports, but also to the weekly law reports, which had the House of Lords and the Court of Appeal of England and Wales, and the English and Empire Digest. The very name of that series is resonant with history, because it was the empire that produced all the cases that were then digested. And if you kept in touch with those cases, you can see the developments in the law. As time went on with the abolition of Privy Council appeals and the change in the law from common law to statute law, the number of references to English authority was reduced, and that changed the content of law that students were taught and that lawyers were practicing and that judges were considering in their cases. And so some people said, in this context, we don't have to know so much about the past. We don't have to study the past, because the past is another country and it doesn't really affect us nowadays, because of the fact that we're mainly dealing with legislative principles of law and constitutional principles of law. And this leads me to the final subjects that I want to address during these remarks, namely the role of history in constitutional cases, and whether or not it is useful in Australia, with our own constitution and with our own constitutional doctrines and the decisions of the High Court as the final word on the Constitution, is it still relevant to know about history? The answer to that question is sometimes it is and sometimes it isn't. It is important to know about the trend of cases in the High Court, because that is part of legal history too. And if you read the trend, you can perhaps see the way in which the court is developing legal principles, and that's very important in advising clients and also in actually advocating cases in the courts, including in the High Court of Australia. But in some cases, it isn't enough to simply look at what the Constitution says and try to find out what it was understood as meaning at the time that it was adopted in 1901. And I want to give two illustrations of this fact, which I think clearly indicate the way in which sometimes it is not helpful, but sometimes it is. The first illustration relates to a case called Commonwealth of Australia against Australian Capital Territory. Now, there have been many cases with that name, but this case was decided in, I think, 2015, and it related to the third attempt of the Legislative Assembly of the Australian Capital Territory to enact a law for same-sex relationship recognition. The first attempt had the word civil union in it, and some members of the federal parliament in the coalition parties said, this is looking too much like marriage, we are against gay marriage, and therefore we're going to disallow it, which they did. The second attempt had the word civil partnership, which was introduced during the Rudd government in the hope that that would get past Mr. Rudd as being sufficiently different from marriage. But because of a commitment that the Labor government had given to the electorate that they would not enact same-sex marriage during the parliament in question, that was also disallowed. And then a third attempt, you have to hand it to the ACT Parliament, the ACT Legislative Assembly. It's a feisty legislature. It may not govern a huge number of Australians, but it doesn't give up easily. And so they tried a third attempt in which they endeavoured to have the provision for same-sex marriage, but it was defined in the ACT law not to be a marriage in the old-fashioned sense. This was only a special, particular, peculiar ACT marriage. But that didn't fool the High Court of Australia, and it went up to the High Court, and in the case of the Commonwealth against the ACT, where the Commonwealth, through Attorney General George Brandis, challenged the ACT law, the High Court struck down that law. However, the court added in the course of their reasons a rebuttal to the suggestion that had been advanced in some of the arguments for the challengers that it would not be a correct interpretation to ask what did marriage in the Australian Constitution, what did that mean in 1901? If you ask the question, what did marriage mean in 1901 in Australia, almost certainly it would not have meant marriage between a man and a man or a woman and a woman. It would probably have conjured up the notion marriage between a man and a woman, because that was the common law notion of what a marriage was at that time. But the justices of the High Court, in their unanimous opinion in Commonwealth against ACT, in 250 Commonwealth Law Reports, said that would not be a correct way to approach the issue. A purely historical search for what marriage meant in 1901 is not the way to go, because the notion of marriage is one which has had different meanings in different countries, especially through the British Empire. In particular countries, it had special meanings in local law, and therefore you have to look at what the essence of the marriage is, and that essence is the relationship between two people. And so the High Court made it clear that if the Parliament enacted such a law, that would be within the marriage power. And that, of course, was the green light that led the Turnbull government to introduce the changes to the Marriage Act, but not before a plebiscite was conducted to decide whether that was acceptable to the majority of people answering the plebiscite by a postal survey. The second illustration I want to give is relevant to an important case that has been decided this month in the High Court of Australia concerning whether an Aboriginal Australian can be an alien under the aliens power that is conferred on the federal parliament by section 51(19) of the Constitution. And this is a provision in respect of which the world expert on the subject, Professor Kim Rubenstein, is here today, so I have to tread with great care in expounding this matter. She's actually written an op-ed, she's given interviews on the ABC, and it would be a good thing if at this stage in my commencement address I simply sat down and hauled her to the microphone and let her explain it. But I want to talk generically about this issue because it also has a history in the High Court. When the Australian Constitution was written, it only had two specific references to citizenship, and they were not for the purpose of empowering the enactment of a law on Australian citizenship, because at the time the Constitution was enacted, back in 1901, the nationality status of all Australians, indeed of all people in the British Empire, was the same. It was that of a British subject. It was not Australian citizenship at all. It was the status of a British subject. And when I got my first passport back in the year 1962, in order to travel at the expense of the students at the University of Sydney to Nigeria, a place which we had to investigate and see after its recent independence, it had on the top of it British subject and Australian citizen. But British subject was the nationality status, and the nationality status was common to the whole empire and was thought to be a personal duty of allegiance to the king or the queen in that time of the United Kingdom. Subsequently, the notion that the king or queen of the United Kingdom was also the king or queen of Canada, New Zealand, Australia, Papua New Guinea, and so on, was a development that went through the local legislatures. And so in Australia, you were a subject of the Queen of Australia and a citizen of Australia after citizenship was enacted by the federal parliament. And so this was a very big change that came about in the Constitution when the citizenship law was enacted, and it then presented a series of problems to the High Court of Australia. And those problems arose during my time of service on the court. The first case was a case called Re Patterson ex parte Taylor. And this was a case of Mr. Taylor, who had been born in the United Kingdom, brought out to Australia at the age of 6, had lived all his life for, I think it was approximately 25, maybe more years. He had no connections with the United Kingdom, no family in the United Kingdom, but he'd never taken out Australian citizenship. His nationality status was that of a subject of the Queen, and he was given a designation under legislation as entitled to an absorbed visa because he came from the United Kingdom, and at least at that time, people who came from the United Kingdom could vote in our elections. That was just something we provided exceptionally for them because of the fact that they were treated as subjects of the same Queen and therefore as Australians. But the Commonwealth, because Mr. Taylor had been convicted of criminal offences, wanted to send him back home. He said home is Australia, but they said, too bad, you haven't got your Australian citizenship. If you had, we couldn't send you back. But like many people who were in his category, he didn't bother getting Australian citizenship because he had been absorbed. That case came to the High Court, and the court divided. Justices Gaudron, McHugh, Callanan and myself held that Mr. Taylor had effectively been absorbed. He was a subject non-citizen, but he was entitled to stay because he was an Australian. He'd been absorbed. That decision was overturned 2 years later. That's a very unusual thing for that to happen in the High Court. Overturned in the High Court in a case called Shaw against the Minister for Immigration. And it happened when Justice Gaudron retired from the High Court. She was replaced by Justice Hayden, and the Commonwealth rushed back to the court as newly constituted, re-argued the matter, and over the dissents of Justice McHugh, Callanan and myself, we stuck to what we'd said in the earlier case. The new majority struck down the decision in Taylor and said it was up to Parliament to decide whether a person who is not taken out citizenship and is not formally an Australian citizen, and there's no basis in the Constitution of any doctrine of absorption, and therefore Mr. Shaw, Jason Shaw, who'd likewise been born in the UK but came out to Australia, he was sent back to the United Kingdom. Later, 2 years further on, in Singh against the Commonwealth, it was not a case of a person who had been a subject of the Queen anywhere. This was a young person who had been born in Mildura, but her parents came out on a business visa from India, and the parents were not British subjects, so the arguments that had been run in Taylor and Shaw could not be repeated in that case. She was claiming, having been born in Mildura, she was born and attached to the land. She had a connection to the land, and therefore, under the Constitution, she was not an alien, and she couldn't be returned to India. She was an Australian national. But that decision went against Ms. Singh, and so it looked as if the position in Australia was clear that the Australian legislation could define who is a citizen, and if you're not a citizen, then you are subject to being sent away. And then, 2 weeks ago, in a case called Love and Toms against the minister, the High Court had to consider whether an Aboriginal Australian could be a person protected by the Constitution. The situation arose because each of them was not an Australian citizen. Each of them claimed to be an Australian, an Aboriginal Australian, and in the case of Mr. Toms, that was not disputed because he'd been part of a land claim under the Native Title Act, and he was recognised by the Indigenous community and could establish his biological connection to the Indigenous people. So he qualified as an Australian. Mr. Love couldn't qualify in that way, and his situation was more uncertain. But in the case of Mr. Toms, he was an Australian Aboriginal, and therefore the issue had to be addressed. And the High Court, by a majority, a narrow majority, decided that he could not attract the alienage power because an Australian Aboriginal could not be an alien to this nation, even though he was not a citizen. Questions have arisen as to whether or not this case will have many implications for our relationship with the Indigenous people I see that Professor Megan Davis, herself an Indigenous Australian, has said that it's not going to have a lot of application, at least in its terms, because most Aboriginals are born in Australia and live in Australia. This is the case of somebody who was born in Papua New Guinea and another who was born in New Zealand, and therefore it's a rather peculiar fact situation for Indigenous people, not a common situation. But it's interesting to me, who helped formulate the notion of absorption in the Australian community, in the Patterson case and in the subsequent Shaw case, to see that essentially the same notion of being Indigenous to Australia, being an Australian, has been embraced in the decision in Love and Tom's, but special to the Aboriginal people. In his dissent, Justice Gageler said that why should it be special to Aboriginals? Is that a discrimin that is desirable in this day and age? Would it drive the Commonwealth back to using the racist power to enact a law that was against the Aboriginal claim in circumstances like this, which he didn't think would be a good thing? It is a bit peculiar, my fellow citizens, that we have in our Constitution one of the very few provisions, I don't know of any other in the whole world, that has a constitutional discrimin on the basis of race. That is, the power to make laws with respect to persons of a race in respect of whom it is thought necessary to make special laws. It's a very 19th century notion, but it's there in our Constitution. As another case, Cartinieri against the Commonwealth decided, it's not only available to make laws that are favourable to the Aboriginal people, it's also there to make laws that are nasty to the Australian Aboriginals, and that itself is something to pause and think about. So, the moral of my story is that legal history matters, but also it's interesting, and it's a story of stories and a story of human stories. I hope you can see that the issue of same-sex marriage affected quite a lot of Australians, and therefore it was a matter that was of interest and concern. It actually affected me, and I've got here my ring, which indicates that ultimately, when the plebiscite postal vote was adopted, the federal parliament got around to enacting it, and after 50 years of living in sin, I was able to marry my partner Johan, and this week we celebrated our first anniversary. It's our 51st anniversary of when we met and our first anniversary of getting married, and so far we're not rushing off to the divorce courts. That would be far too heterosexual for us to do. But the story of Mr. Taylor, Mr. Shaw, Ms. Singh, and Mr. Love and Mr. Toms are human stories, but they're part of the history of the emergence of the understanding of our Constitution. And it's through history that we understand our law, and it should therefore be taught. If not compulsory, it should at least be encouraged. And if encouraged, I think you'd get a lot of students taking courses in legal history and seeing their law in context of the canvas of legal history as it affects our country and its legal system. So that is what I come to say as the commencement orator on this occasion. We will have a huge round of applause and then some Q&A.
On behalf of the student body, as well as the Canberra Law Student Society, I would like to say thank you for your attendance today. It's always very special hearing from you, and you have definitely made this commencement oration all the more special with your attendance. Thank you very much. I will now hand over to Professor Jane Diedrichs, who will start the panel off. Thanks.
No, I'm okay.
Thanks, Natasha. Thank you for the promotion as well at that point. I'm Jane Diedrichs. I'm in the School of Law and also in the School of Business, and my areas of great interest are human resource management and employment law, which we've recently renamed workplace law. And my question picks up on that theme and the story of how we now interact in the workplace, not just as employees, but as independent contractors, and anything under the sun, it appears. And so there was a recent judgment where the Deputy President said that the law of employment really needs to evolve in Australia, and we need to catch up with the evolving digital marketplace and particularly the digital economy. So I'd like to know, Michael, what are your thoughts as to the focus areas for the development or improvement of the legal framework concerning how workers and organisations operate in this new environment? The question is essentially, in today's world, we're not all employees. We can be independent contractors. We can take place in a market that the law of employment just hasn't grappled with. So what do you think would be some of the key areas that Australian employment law or workplace law could focus on for the rights of workers and possibly the rights of organisations?
Well, the actual language in the Constitution is not employment law, and therefore you're not confined to the notion of employment. The words in the Constitution are engraved on my heart. Conciliation and arbitration for the prevention and settlement of industrial disputes extending beyond the limits of one state. Every one of those words was the subject of 100 cases. And suddenly, in the year 2002, I think, in the workplace work choices case, all that jurisprudence was swept into the dust can of history when it was held that legislation could be enacted under the corporation's power in the field of industrial relations and employment disputes, or quasi-employment disputes, or non-employment disputes involving work and activities or services. So I don't think the question you ask is actually really part of the problem of the Australian Constitution. The problem is presented by the dissenting opinions in the work choices case, which were written by a rather unusual combination, Justice Callanan and myself. This was to the effect that because our Constitution had taken the trouble of saying that in the event of industrial relations disputes, that would be governed by a subparagraph of Section 51, which was subparagraph 35, laws for the prevention and settlement of industrial disputes extending beyond the limits of any state. And that meant that because they'd taken the trouble to make that very specific in that particular area of law, you couldn't use a general corporation's power to ride roughshod through that, making it completely useless to have the conciliation and arbitrations power. In essence, that is also supported by the history of how that provision was enacted. It was enacted because the founders were not willing to give the federal parliament power to enact laws on work. They insisted that it should only be setting up an arbitration commission in order to decide these matters independently after argument. That was what we did, and that was how we did it for 100 years and more. The position has been overtaken by the work choices case, and all those words of 5135 have absolutely been discarded. But your question doesn't really arise in a constitutional context, because there's nothing in the Constitution that limits you to notions of employment or extended notions of employment. It just has to be a law with respect to a corporation of a constitutional character. Any other questions or any comments? Does anybody disagree with what I've said? Professor Rubenstein, do you have a disagreement?
I don't, but I have been given the opportunity to prepare a question for you, so I might follow suit. And I might also clarify for the students here that I'm not in fact the deputy to Professor Lacey, but in fact I've come across to UC to head up, to be the co-director of the 50/50 by 2030 Foundation, as well as being a professor in the law school, and I'm really delighted to participate in this event. My question to you is linked into the nature of the foundation, because back in 2002, Michael, you observed that only 6 women had speaking parts before the High Court on that particular year. And in fact, in recent research that the Foundation's publication outlet, Broad Agenda, just published, the paper found that not only do women judges get interrupted twice as often as male judges, but that the interruptions actually increased after Justice Kiefel, Susan Kiefel, became Chief Justice. So while female judges received 54% of interruptions before 2016, following Justice Kiefel's elevation, that increased to 69% in 2017. So my question is, what is your sense of what is needed to change this form of bias against women in High Court practice?
I think steps have been taken because of the consciousness raising about the sort of issue that is revealed in that recent research. I also read the coverage of that research showing that women judges, including the Chief Justice, are interrupted more than male judges when they're asking a question or making a comment. And that is really just discourteous, and it's a sense of bullying, really, in a way. And I think often it's unconscious. And that was, I think, one of the conclusions of the researchers, that this is just disrespect to women judges that wouldn't be showed to the male judges. And having drawn that to notice, I hope that that particular aspect of inequality will begin to disappear. If I were still on the court, if that glorious moment ever arose, that I was still there and somebody interrupted me, I would say, you're interrupting me as much as though I was a woman judge, and this is completely unacceptable, and people should wait until I've finished my observation. I must say that when Justice Gordon, the first woman judge appointed to the High Court, was on the court, and I was sitting there, which was most of my time on the High Court, I wasn't conscious that she was interrupted. But it may have happened, and it would be interesting to look at the statistics in her case. She was an extremely forceful and powerful person, and I would think if people had interrupted her, she would have told them where to get off and to wait until she'd finished asking the question before you interrupt me. And maybe that's what has to be done. People have to stand up and to express themselves very clearly and emphatically, because that's the only way that bad conduct is called out and hopefully then changed. Stress, pressure, rudeness, bullying, all of these things are unfortunately part of the old ethos of the law. But what we've got to do is make sure that those particular aspects of our profession are consigned to legal history and that they're not part of the current practice of the law in Australia, which should be equally courteous between all people. I knew some High Court judges who were very rude. They were brilliant judges. They were judges I admired as a law student, but I'd then go up to the High Court as a young law student or as a young lawyer, and I would see them in action, and they were extremely rude. Justice Kitto, Sir Frank Kitto, who was a great judge, a really great judge, very bullying. Chief Justice Barwick, very bullying. Justice Taylor, very bullying. And the Court of Appeal of New South Wales basically copied them because the highest court sets the standards in a sense. And it was also very bullying, and in fact some barristers fainted and had to be carried out during my time as a barrister because of the rudeness of the judges in the Court of Appeal. When I came as president, I was determined to change all that. I'd been brought up in a very loving family, and we'd all been courteous to each other and to other people, and that is what I insisted on. And when my colleagues broke that rule, I would say, Justice so-and-so speaks for himself. He does not speak for the court, and he does not speak for me. And after you start doing that a few times, then the misbehaviour ceases. And I think that was a good thing I introduced in the Court of Appeal. And I believe the High Court is much more courteous nowadays than it was in the time of Barwick, Kitto and Taylor. Very clever judges, uncorrupted judges, fiercely looking for their solution in the case, but just bad-mannered. And it's not on, has to stop.
Similar to Professor Rubinstein, in a speech in 2013, you said the practice of law was exercised by elderly privileged Caucasian males, atypical in their life experience. Access to justice for those outside that privileged class remains, particularly for the vulnerable, remains very challenging. Short of all becoming activist High Court judges, how can we as students and law practitioners do better to reflect the law enabling all experience rather than that of the few?
What's the question? That got lost in the ether.
Got lost in the ether. How can we, as students and practitioners, enable the law to reflect the experience of many, not just elderly privileged Caucasian judges?
Yeah, well, we can do it. It has to start in a law school. It has to start with making sure that the people who come into the law are a cross-section of the whole of our community, not just specially privileged people, but people who are part of the Australian community and reflecting the variety of it. I think that's a good aspect of the University of Canberra, and it's not a fault of some of the sandstones that they don't necessarily have the same makeup, but values in, values out. If you bring into law, in law school, values of an elite kind and a privileged and born to rule kind, you're not necessarily going to have different values when you get to the judicial seat. You're going perhaps to reflect the same, and we have to make sure that this changes and that the law does reflect the whole of our community right up to the top levels and in the judicial branch. but also in the making of our laws and in the application of the laws and the teaching of our laws. I think we need to make sure that there is a place for everybody. Equal justice under law means what it says, equality for all people.
I had a question for you. In your years as a judge, has there been a case that has affected you?
Have I?
Has there been a case that has affected you the most?
Is it a case that I liked most?
That has affected you?
Or case that affected me the most? Well, I'll be completely candid now. I never had difficulty sleeping. You've got to be able to sleep. In the legal profession, you've got to have a good sleep. It's something about your internal computer. It needs to clear and be able to cope the next day. And so I always had a good sleep. I had a wonderful family and then a marvellous partner with whom I could talk. And that's very important, to be able to do that and debrief and complain, including complain about your colleagues and about the litigants and about everybody on earth. But did any of the cases really affect me? Well, you know, a lot of students ask, what is your favourite case? Well, I love them all. When I used to ask my father, now, who is your favourite child? We've got two brothers of mine, and one sister, so that's 4 children. If we're on the Titanic and it's about to go under, which one would you save? And he would say, well, I'm a very good swimmer. I would go round, I would save you for a few minutes, then I would save David for a few minutes, then Diana, and I would save you all, and in the end, none of you would drown. I might drown, but you would survive. And so I felt the same about my cases. And, you know, I never lost the wonder of the privilege of being a Justice of the High Court and having that privilege of being the final court of a free and democratic country. And I looked across at the High Court building when I came here. It's now 11 years since I served on that court, but it is a great privilege to be a judge in a court which is highly talented, very skilled, and uncorrupted. That is not true in most countries of the world, but it is true about Australia. And so none of the cases led me to have no sleep. I just did my best, and even when occasionally I was dissenting, and sometimes dissenting on my own, if I really was sure that what I was saying was a lawful and correct view of the law, I never worried that others disagreed with me. I mean, that is the good thing of our system. It isn't true in Europe, and in the civil law tradition, the judges are not allowed to dissent. Can you believe it? But in the English system, the judge must give their truly honest opinion of the case. And that is what I always did. And I believe that is what my colleagues did, even when I totally disagreed with them. And I wondered, how on earth could you come to that conclusion? Like in the case of Shaw. People have different views. Maybe they have different views sometimes because they start from different premises. But so long as those views are the honest, uncorrupted, independent views of the other judges, they're entitled to their view, I'm entitled to my view, and we each have the obligation of stating it and writing it down. And you get more work if you disagree, because if you agree, you can just send around, I agree with Justice Gummo. But if you don't agree, you've got to write your reasons, and that's hard work. So basically, no case really disturbed me. I mean, I was upset some of the decisions. Shaw was one of them, because it basically changed the law as a result of Justice Gaudron going off and Justice Hayden coming on. Changing the law in a 2-year space is not a usual thing to do, but it was done in that case. But it's interesting to look back now at Patterson and Shaw in the light of the notion in the Love and Tom's case that there is at least one category where you can't just throw people out of the country because they have a constitutional entitlement to stay. And that essentially was what we were searching for in the majority view in Patterson, to say, because he had been born in the United Kingdom and was a subject of the Queen and was here for 25 or 30 years and had no connection with the United Kingdom now, he's our problem. He's not the United Kingdom's problem. But he had to go when the Shaw decision reversed it.
Thank you, everyone. We've got to draw this part of the day to a close now. We've got lunch and drinks outside. Can I just ask you to join me in thanking everyone that's asked a very thought-provoking question, and thanking Michael Kirby for his time and his inspirational words for us this morning. Thank you.